Hi, this is Peter Tracy again for Ameritech Ventures. I dropped the call by accident, so I'm back in.
Okay, thank you. Is
Thank you.
there anyone else on the line who needs to check in who's not done so already? Are we waiting for anyone else on the Ameritech versus Clinton Stokes case?
Not that I'm aware of.
Oh, Sean's on. It's off. How do you do it? The what?
The dash at the bottom.
Uh-huh.
Turn it down.
Thank you.
Board is back in session.
Thank you, everyone. Give me a second to get booted up before I call the case at 11. Okay, on page 9, we have Ameritech Ventures versus Clinton Stokes III. Appearances, please.
Peter Tracy for Ameritech Ventures, bar number 7650.
Thank you. And Mr. Tracy, I see that you have obtained service of Mr. Stokes in California.
Yes,
Did any
Yes,
contact?
we got him. I'm sorry, no, I have not received any contacts from Mr. Stokes. I did receive contact from his counsel in the custodian case yesterday, indicating that she had not been retained.
I see.
And I have been, as of this morning, Your Honor, I'm on as well, Rebecca Fuller, bar number 9809 for Mr. Stokes.
So, you cut out at the beginning. Can you just repeat that, please?
Oh, I'm so sorry. Rebecca Fuller, bar number 9809, appearing on behalf of Mr. Stokes.
And you are appearing on his behalf today?
That's correct.
Okay, very good. Then, I've read everything and I looked at the custodianship case. So, Mr. Chasey, what it looks to me is though there's a dispute as to whether or not the fiber optics assets were transferred. And I am, you argue that because there was a security interest in PPP Engineering, through Meriden, who lent money to them, and then I assume, Ms. Fuller, you will say that there's no security interest in the property was delivered. So is that correct?
That is correct, and I do have more detailed arguments in that regard, but I'm happy to address those whenever you'd like.
Good enough. So let me hear from Mr. Chasey on the motion now, and then I'll give you a chance to argue in opposition.
Your Honor, it does appear that you understand the fundamentals of our position. Essentially, in August of 2017, Mr. Stokes sold fiber optic assets to the corporation. And the corporation certainly does not have them now. And when the public reports were audited, when the auditor for this corporation had no choice but to write the asset off. So in the quarterly report filed just before the annual, I believe it was February of 2018, the fiber optic assets were listed as $100,000. In the subsequent annual report filed 3 months later, the corporation listed the fiber optic assets as worth $0. Now, the reasoning for that is that when the auditor had to look and see whether or not the assets actually existed, couldn't find them. Now, same thing is happening now. The custodian has control of the corporation and does not have the assets. When we looked into it further, we see that the promissory note between Mr. Poff and PPB, we believe that they're referenced as Meridian, Your Honor, but Meridian's note to Poff and PPB contained a security agreement with a prohibition of sales and transfers for the collateral posted by Mr. Poff and PPB for all of the assets of PPB, the mechanical engineering firm operated by Mr. Poff. So the only evidence that's come to light to date concerning how Mr. Stokes supposedly acquired this is the declaration by Mr. Kenneth Mayo, the former Secretary and Treasurer and Vice President of Operations for Ameritech, who says that when he came on board, which was in July of 2017, the assets were already owned or controlled by Mr. Stokes. Well, less than a year before, Mr. Poff had pledged all of those assets as security, and we know that they're still in So because of that, we know that Mr. Poff could not have transferred the asset to Mr. Stokes, who later claims to have transferred it to Ameritech Ventures. And we know this in large part because of the language of the agreement between Mr. Stokes and Ameritech Ventures. He sells all right and title of the assets. It listed in Exhibit A to the buy-sell agreement. And there's a description of technologies. Elsewhere in other public reports, it's identified as intellectual property with capital I, capital P. It's also referred to as proprietary technology. What we do know is that Mr. Stokes didn't develop it. He says he acquired it from Mr. Poff. Well, Mr. Poff didn't have the right to do that. So without that, Mr. Stokes could not have delivered the asset, the fiber optic asset, to Ameritech Ventures, who presently does not have that. So we believe that this presents a likelihood of success on the merits for both the breach of contract claim against Mr. Stokes and the claim for declaratory relief, both as to Mr. Stokes' non-performance and as to the impossibility of his performance. If you'd like, I'll address the bond issue.
That's premature.
Okay, thank you. Then plaintiff rests for reserving rights to argue you in reply.
Thank you. And the opposition, please.
Thank you, Your Honor. What is really interesting to me here is that what plaintiff completely fails to mention is that there's already an action pending in the Los Angeles County Superior Court regarding these same parties and dealing with these same issues that was filed back in 2019. This included a claim for breach of contract as well as tortious interference relating to the stock that's at issue in this case. Since we're on shortened time here, we obviously haven't had the opportunity to move for a stay of this action pending the outcome of that prior filed California action, and such, we're bringing the opposition today. What we have here is a situation where the custodian is really acting out of his own self-interest rather than that of the company. And his activities, this case, in both the appointment as custodian and in the case that's pending now before this court, are to frustrate Mr. Stokes' efforts to his stock, all the while dumping his own stock in the company. We have a situation where, with respect to the TRO or injunction request, we need to look at whether there is irreparable harm. And we don't have a showing of irreparable harm. We have a publicly traded company, and on the day that the restrictions are lifted on the stock, there will be a published trading price for that day. The trading price will establish the value of the shares, and if plaintiff were to prevail in this action or in the California action, that would establish the amount of monetary damages related to the shares of stock. So far, evidence of irreparable harm that he's presenting to the court is really just the declaration of Mr. Pasley. And despite not being an expert or having any qualifications indicating that he's an expert, he's offering his opinion testimony predicting a future of what might happen without any foundation for doing so. And his own testimony is contradictory. He's arguing that if Mr. Stokes were to sell all of his stock, the price would crash. And there's no evidence, number one, that Mr. Stokes would even sell all of his stock, but also why would he want to devalue his own asset by doing so? Mr. Pasley is also arguing that people will find out that the shares were procured in exchange for fiber optic assets that were never delivered to Ameritech. But Mr. Pasley's declaration in this case, as well as declarations made in the other action where he was appointed as custodian, are already public record, and he's the one who's putting that information out into the public, not Mr. Stokes. Again, Mr. Stokes denies that those statements are even true, that he did in fact procure the fiber optic technology and did validly sell it to Ameritech in this transaction. Additionally, it's Mr. Pasley saying he fears that, if more shares are put on the market, that it will lower the stock price. But then in the very next sentence, he talks about putting more shares on the market in order to raise funds. So these are clearly contradictory statements. Without any foundation, he's stating that if Mr. Stokes' shares become restricted, the company won't survive. But we have no idea as to how or why the company would not survive based on those shares being placed on the market. He makes no statement that Ameritech needs to raise funds or that it intends to issue more shares. And additionally, Judge Denton's order in the underlying custodian case is public information that Mr. Stokes' shares in this company become unrestricted as of today based on his order. And so, the company is still in business as of right now. There is no, as of this moment, there's nothing in place that would prevent any sort of restriction, and that hasn't affected the assets or abilities of the company at this point in time. Additionally, Mr. Pasley is trying to predict what shareholders might do, but we have evidence of that because they've had 10 days to prepare since that order went into effect. There have been a number of people, I think, that have been watching what the outcome of this action would be based on Mr. Pasley sharing that information with not only the general public, but shareholders specifically of this company. The only case that Mr. Pasley has cited in demonstrating irreparable harm relating to the sale of shares is this, I believe it's Avoyelis versus the state of Lilladal case, which is a Louisiana case. And that enjoined a sheriff's sale of restricted shares in a very small family-owned company that only had 2 shareholders. With this case, we have over 10,000 shareholders. In that case, of course, you can't have 2 strangers, operating a business together without any sort of prior relationship or ability to come together. Here we have 10,000 shareholders, and it's a publicly traded company. This is a much different circumstance. We don't have a concern that these shareholders are going to be stepping in and running this company. We don't believe that the plaintiff has demonstrated any likelihood of success on the merits. He argues that the company will prevail because Mr. Stokes didn't deliver any rights or title to those fiber optic assets. And as evidence, what he's attaching is a stack of documents without any authentication or foundation, and providing no declarations with firsthand knowledge of any of these facts.
There's a lawsuit in California.
And, we have this argument that Mr. Stokes didn't deliver the rights or title to these assets. And as proof of the contention, he's referencing specifically in footnote 24, this balance sheet. Exhibit 5 is the annual report, which includes the balance sheet, and the balance sheet actually only shows that the fiber optic assets are in the asset column, but leaves that value blank. And the reason the value is blank is revealed at note 4 of the same document. It says fiber optic assets at page F8, and it states, the terms of the asset purchase agreement were fulfilled on September 15, 2017. Further, the company determined that based on uncertainty of the estimated future cash flows associated with the acquired fiber optic assets, the carrying amount of the fiber optic assets and impairment loss of that amount was recognized and is included in the net income. The company still has plans to utilize the fiber optic assets once funding has been secured to implement the company's future business development plans. So in other words, Ameritech is stating that it owns the asset and that it's using it as a write-off in the current accounting period until those assets generate cash flows. There is an acknowledgement that those assets were received. We then have the argument that Mr. Stokes could not have obtained the assets from Mr. Poff, and the proof that they're relying on is an old security interest, again without authentication, in Exhibit 11. And there's no evidence that PPB, the company referenced in that agreement, ever owned these specific fiber optic assets. Additionally, there's no security agreement that encumbers Mr. Poff's assets, only PPB's assets. And then additionally, there's no reference to the fiber optics assets within the security agreement. And finally, that very security agreement that is being referenced was paid off and released. So there is no security against these assets in question, even if those assets were the same ones that were referenced within the security agreement. Now, when we look at the balance of interests here, we believe that it favors defendant Mr. Stokes. When we're looking at the irreparable harm, it's really just an argument, again, which was asserted in the custodian action itself, of irreparable harm and this false claim that Mr. Stokes never transferred the assets. We don't have any documentation to show that they weren't in fact transferred. On the contrary, we do have the statements from the company that show that they were. Mr. Stokes delivered these fiber optic assets to Ameritech. They're referenced in the annual report. The payment for those assets was the stock at issue. And so what essentially will happen is that if these restrictions aren't lifted, Ameritech will have a windfall for obtaining this property without paying for it. If the California court determines that Mr. Stokes breached the agreement, or vice versa, that Ameritech breached the agreement, we have rights to monetary damages. And that's based on the value of the stock the day that the restrictions are removed. There will be concrete damages to be established. There's no irreparable harm here. Additionally, Mr. Pasley's arguing that the public is relying on the truth and accuracy of the disclosures made by a publicly traded corporation. And what's interesting is that he's actually asking this court to declare that those public disclosures show that the ownership of the assets is false, that it didn't occur, and by finding that there's no assets owned by the company. Accordingly, based on plaintiff's own arguments, if the court made that finding, it would disrupt the faith in those public disclosures. Now, finally, with respect to the bond issue, obviously, if there were a injunction issued, we would request a bond. We believe that the fair market value of Mr. Stokes shares based on today's market is about $500,000, and we have this situation where the custodian is slowly dumping his own stock, and we think he's likely to abandon the corporation after he does that, at which time that stock price goes to zero. And so Mr. Stokes has no real protection here, despite owning a relatively small amount of shares in the grand scheme of the entirety, but a fair amount total of over 19 million. And, if the court would grant the application in light of both the pending action in California, as well as the arguments and evidence presented today, that bond should be at a minimum $500,000 based on the current market value of it.
Can you tell me what the status is of the California action?
As of right now, I do know that there was a third amended complaint that was filed in that action. Ameritech had previously been in default prior to the filing of the amended complaint. Obviously, that sort of resets the time frame. I'm not sure exactly what the status of service of that third amended complaint is, or if the clock has started ticking for Ameritech's response to that as of right now, as I'm not involved in that particular action.
Is Mr. Stokes the plaintiff in that case?
He is. So there was and let me pull up the specific. I'll give you the case number and information specifically. He was, I believe, a cross complainant. And bear with me just a moment. I can get that information for you.
Your Honor, this is Peter Tracy. If you want, I can explain the California case real briefly.
We'll give Ms. Fuller a chance here, and then I'll give you a chance, of course, to reply.
Thank you.
There we go. Okay, so that case is Meridian Pacific Holdings was the plaintiff versus Ameritech Ventures as defendant, as well as Lion Den LLC, PPB Engineering, Michael Stokes, Constantina Friel, Kenneth Mayo, Jamie Mayo, and Clinton Stokes. And then there was a cross complaint that was done by Mr. Stokes against Ameritech for breach of contract, as well as tortious interference with respect to the shares.
Do you have the case number?
I sure do. It is 19, S as in Sam, T as in Tom, C as in Cat, V as in Victor, 15991.
And you said LA County?
Yes, that's correct. It's Superior Court, Los Angeles County Central District.
Thank you, Ms. Fuller. Mr. Chase,
Thank you, Your Honor.
reply.
Yes, let me address jurisdiction and venue first. The asset purchase agreement, the only agreement at issue in this case before Your Honor, on the fourth page, paragraph 12, provides that the state courts of Nevada are exclusive venue and jurisdiction for disputes arising from this case. As far as I know, the California case does not touch on this agreement. The California case is Meridian suing everybody, Mr. Stokes, Mr. Mayo, Mrs. Mayo, Wesley Poff, PPB, etc., alleging that they were, for want of a better term, scammed. That there was never any valid business plan, and that it was I believe that there's a conspiracy charge. I know there was at least 13 different claims in the complaint I saw. So the contract before Your Honor, which gives rise to the current disputes before Your Honor, provide for exclusive jurisdiction in the state courts of Nevada. There is no other pending Nevada case which addresses this issue. Ms. Fuller makes the allegation that the custodian is dumping stock. She mentions that more than once. That's a serious allegation, and my client absolutely denies that. And if there's any evidence to the contrary, I would like to see it. I don't believe it exists. I believe that's a statement which has no foundation. It certainly is the case that there are a number of people on a number of different social media platforms tracking this case. And which ties in somewhat to the irreparable harm aspect. The case before Your Honor is whether or not the former president of a public corporation who claims to have sold fiber optic assets to the corporation in an arm's length transaction and claims he delivered, and in exchange received $100,000 and almost $20 million 20 million shares of stock. The evidence before Your Honor shows that, yes, the corporation claims to have the asset, but wrote it down to zero value because the carrying costs outweighed the utility. That's another way of saying the assets, to the extent they were received, are completely worthless. Judge Denton never removed the restrictions from the stock. He stayed removal of the restrictions from the stock, and on April 12th, he ruled that 10 days after, which would be today, the stay is lifted. He didn't affirmatively rule that the restrictions would come off. I may have misunderstood Ms. Fuller when she was making that argument, but I just wanted to clear that up. The public reports attached to Ameritech motion are certainly within the judicial notice provisions by which this court can take judicial notice of a publicly filed document that, in this case, is expressly intended for reliance by the shareholders in situations very, very similar to this. Ms. Fuller made the argument that the security agreement in which PPB pledged its collateral, its assets, as security, and that is, she accurately points out that that security agreement is signed by Wesley Poff as president of PPB, not by Mr. Poff personally. The idea that Mr. Poff sometime developed an incredibly valuable proprietary technology for the manufacture of fiber optic pre-folds and did it personally in his own name outside the scope of his mechanical engineering firm That's that. It does not pass the Smith test. That's not a reasonable assumption. That is an incredibly unreasonable assumption. And I want to close with addressing the bond. The shares right now are worth about 3 cents, 2.5 cents a share. And if Mr. Stokes prevails, it will be because he shows delivery of the asset. If Ameritech Ventures has this brilliant proprietary technology and can track it down and show that it actually owns it, then the shares in this corporation will be expected to rise, which Ms. Fuller indicated that Stokes has no intention to sell. So where's the harm? If he doesn't sell his shares and the corporation is shown to have a very valuable asset, contrary to Ameritech's allegations, then the share price will be expected to rise. There's no harm in letting Mr. Stokes ride it out then. On the flip side, if Mr. Stokes is able to remove these restrictions and flood the market with 20 million shares, first off, I would urge that Mr. Passley is probably an expert. He's been involved with publicly traded companies and the management of publicly traded companies for at least a decade. And he's got the experience, education, and training to testify to these matters. It's also common sense. If this corporation, which already died once, is allowed to, if Mr. Stokes is allowed to take 20 million shares received in exchange for this asset that he didn't deliver in 2017, and in this time he's allowed to put those shares on the market, the confidence in the valuation for this company is going to go down the drain.
He needs to say he once walked away from it 15 days
very
before.
Significant trading.
He sucks.
By people recognizing that, hey, number one, there's an additional 20 million shares, and it's not backed up by any asset. And finally, with this tying this directly into the bond, perhaps $500 is. I believe that Ameritech Ventures believes that $500 is a reasonable bond given the lack of expected harm under any circumstance to Mr. Stokes. If he can't prove that he delivered the asset, shares are not going to be worth anything. He might be able to trade them. If he does prove that he delivered the asset, then the corporation's got an additional asset. That's great. That's going to increase the valuation. So perhaps the best approach to the security requirements under Rule 65 would be to have Ameritech Ventures pledge as security for the bond all rights and title to the fiber optic assets that Mr. Stokes allegedly delivered to the corporation. That would solve two of the problems two of the questions before you're on it. Number one, if the asset exists, then it's great security. If it doesn't, it covers the harm to Mr. Stokes, which would then be close to zero. We believe that that Ameritech Ventures satisfies all 4 requirements for the breach of contract. We believe that we're entitled to declaratory relief, and we request a preliminary injunction based on irreparable harm and likelihood to prevail on the merits. We would ask that the court set a relatively quick trial schedule. Let's get this thing to trial. Everybody wants it done. We can go very quickly, obviously, pending Your Honor's calendar, but we're ready to go. We don't need much more. Thank you. I rest.
This is the plaintiff, Ameritech Ventures, request for injunctive relief with regard to stock in the possession of the defendant. I looked at this case a little differently because if it had been brought as a request for a prejudgment grant of attachment, which is really what it appears to be, rather than an injunctive relief, I would have been required to set a bond based upon the value of the stock, which admittedly is at 2.5 cents, $500,000. So I'm being asked to enjoin a person who has stock from being able to sell their asset, and I just don't find it appropriate for an injunctive relief or even at this kind of restraining order. The argument with regard to irreparable harm is really money damages. It's not.
This sucks.
I don't have enough here to tell me that an action of this defendant will put the company out of business. I have the conclusions by the custodian who is removed from the original business. The defendant has given me a very plausible explanation with regard to the way that fiber optics assets were treated in public reporting, and balancing the interest of based upon the allegations of a complaint restricting the defendant from using his own property is I just find it's too harsh a remedy at this point. I don't know that there's really a public interest. If there is, of course, it would be in preserving value for the shareholders of Ameritech Ventures. But in the analysis I'm being asked to make for injunctive relief, the plaintiff just can't meet the test to do that. So for those reasons, the motion will be denied. It will be denied without prejudice, so that if obtain additional information, you may re-request relief from the court with regard to this case. Even if I thought injunctive relief would be appropriate, more than likely I would consolidate on the merits and just get you guys in as soon as possible. Get a result for both sides that gives you certainty. So that's really important. I'll ask Ms. Fuller with preparing the order. Mr. Tracy, I assume that you will want to review and approve the form of the order?
Yes.
And, you're not foreclosed from looking at NRS 31 on pre-judgment writs of attachment, but this application did not satisfy the statute.
Thank you, Your Honor.
Thank you, Your Honor.
Right.
Your Honor, Your Honor, this is Peter Tracy again.
Yes.
Yesterday we were able to serve the complaint on the complaint and motion and minutes on Mr. Stokes, but the summons had not yet come back. May I understand that Ms. Fuller's appearance for Mr. Stokes negates the necessity of reserving Mr. Stokes with the summons?
You filed a certificate of service yesterday indicating that everything had been served on him yesterday at 10:38 a.m.
That the complaint, motion, and minutes had been served on him. We had not yet obtained the summons at the time service went out. So the summons has now been issued, but we did not have it at the time.
Yeah, the summons was issued on the 19th, and the proof of service indicates that summons, civil complaint, exhibits, motion for preliminary injunction, ex parte motion to shorten time, 4 minutes was served. So, Ms. Fuller, is there going to be a dispute on this?
Your Honor, my understanding is that the summons was not served, which obviously is a defect of service. I think that can be easily remedied, but I don't believe it was actually served. And if that's what the affidavit of service states, I think it is patently false, even based on Mr. Tracy's own admissions.
All right. So, if the dispute can't resolve that between yourselves, you can bring it to my attention.
Thank you.
Thank you, Your Honor.
Okay. Thank you, Your Honor.
All right. Stay safe and healthy, both of you.
Thank you. You as
Thank you.
well.
Motherfucker.
Rebecca nailed it.
She did a good job. Barney wouldn't let that shit happen.
She nailed it. And then Peter just shot himself asking all these questions at the end. Wow.
I just fucking dumped it.
All of it?
Mm-hmm. While she was doing that, I just hit sell, everything. Just dumped it all.
What is it at right now?
3 something. I mean, I can buy it back. I'm not worried about that. It's fucking